When a defendant complains about his assigned counsel's representation and wants a new lawyer, does the court have to provide that new lawyer? To find out, you have to read People versus Divine Fredericks, but it's 20 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Divine Fredericks. The citation for this case is 2025 New York Slip Opinion 01011, published by the New York Court of Appeals on February 20th of 2025. The two issues in this case are whether the defendant's complaints about his assigned defense counsel are factually specific and serious enough to require the trial court to engage in a minimal inquiry to determine whether relieving that counsel is required and replacing them with a substitute assigned counsel is necessary. And the second question, the second issue this case addresses is whether defense counsel's responses to this complaint were themselves sufficient enough to require substitution of counsel. Okay. To understand and appreciate the context of this case, the helpful background to know is that the New York and federal constitutions require that a defendant be given right to counsel, including right to counsel even if indigent, meaning right to assigned counsel for people who can't afford to retain hired counsel. But importantly, the right to assigned counsel does not encompass the right to successive assigned counsel. You can't say, I get this assigned counsel, I don't like you. I want another assigned counsel, and I don't like him. I want a different assigned counsel. The Constitution does not require that. A defendant may be entitled to new assigned counsel, upon a showing of good cause for substitution, such as a conflict of interest or irreconcilable conflict with counsel. So if there's conflict of interest or an irreconcilable conflict, then counsel will be replaced, relieved and replaced. And the trial court has a role in that process. The trial court has a duty to investigate complaints made by an indigent defendant about their counsel, but it's in the discretion and responsibility of the trial court whether to conduct that replacement. The trial court's obligations to consider a motion to substitute counsel are invoked only when the defendant makes a seemingly serious request. That's the language, a seemingly serious request, which comes when the defendant makes a specific factual allegation of serious complaints about counsel. And if that happens, the trial court must make a minimal inquiry and of the counsel to determine whether this is like a serious issue that can't be resolved or can it be resolved. And that minimal inquiry is supposed to discern meritorious complaints from disingenuous applications by inquiring as to the nature of the disagreement or its possible resolution. And complaints that are serious are ones suggesting a serious possibility of irreconcilable conflict, or sometimes a complete breakdown of communication and lack of trust in the relationship. Okay, those are kind of things that require the court to engage in that inquiry. And but what's not required to be engaged in is a complaint where it's just if it's just based on frustration. If it's I don't like my lawyer because I don't like my lawyer, that's just a frustration, and it's not required to. That does not require a judge to engage in a minimal inquiry of the situation. So what are the facts here? The facts are that the defendant was alleged. The allegations here are the defendant and his friend were riding in a car. The defendant was in the back seat after a night of drinking. While still inside the car, it's alleged the defendant shot the front seat passenger with a gun in the head and the driver in the chest and the jaw. The defendant and a friend fled. The front seat passenger died, but the driver lived. The defendant was then indicted on a number of charges, including murder and CPW, criminal possession of a weapon. And the defendant was indigent, so he was provided an assigned counsel, right? A counsel provided by the court system. Several months into the proceeding, the defendant wrote a letter to the court complaining of his counsel and explaining frustration that he had with his lawyer. In the letter, he said, my assigned attorney isn't working in my best interest. I don't want to keep prolonging the proceedings anymore. He disregarded my request of visits, even by video. He hung up on me and disrespected my wife. He's aware I don't want him on the case anymore. He's not working in my best interest. He's actually arguing the issue for the district attorney. He wants a new attorney assigned that's going to fight to get the truth out because, in fact, the defendant is innocent. And the defense counsel just keeps telling him to take a plea. That's the letter. In response, the next time it's on in court, the judge says to the counsel, are you aware of this letter? The defense counsel says, no, I'm not. He says, okay, I'm going to adjourn. I'm going to have a brief recess, let you read the letter, and then explain what you want to say. And defense counsel then says, when the court asked him to examine the motion and make a determination whether it had legal merit, the counsel said that it was a shooting the messenger situation. Sometimes you want to shoot the messenger as opposed to, he doesn't like the message. And I and my investigator have gone over this stuff with the defendant a lot of times. We've gone over everything. He just doesn't like what I have to say. Okay. And the court then says that the court then analyzes this and says, I'm denying the application to change counsel, to relieve counsel. And you're staying with this counsel. That counsel then conducted the trial for the defendant. The defendant was found guilty by a jury, and he made a motion to appeal. And in that motion to appeal, he said, ineffective assistance of counsel. One of the complaints was this counsel was not for me, and I was denied my right to substitute counsel based upon these problems that he had. The Supreme Court denied the application to vacate the conviction. The appellate division affirmed the order and judgment. It goes to the Court of Appeals. And here we have a 4-3 split where the majority says this trial judge was right. The appellate division was right. The majority, this is a 4-3 decision again. The majority says the defendant's assertions that counsel was not working in his best interest and was all these complaints he made did not rise to the level of a minimal inquiry. It was too conclusory. There were simply no facts elucidating these allegations that would have signaled to the trial court that a serious conflict emerged between defense counsel and the defendant. And there was no genuine conflict, that any conflict or the conflict was irreconcilable. And in any event, they say the court did engage in minimal inquiry. They asked counsel, what's going on here? And counsel said, it's frustration. He wants to shoot the messenger. That's what's going on here. So it did not rise to the level requiring minimal inquiry. And here there was a minimal inquiry, and it was sufficient. So they denied defendant's application. On the other hand, the 3-person dissent here says, as to both questions, this was a serious violation between defense counsel and defendant. It did rise to the level of minimal inquiry, and there was not a minimal inquiry given here by the court. So the dissent would reverse and give a new trial with a new counsel, and the majority affirmed the conviction, said the trial judge was right in their use of discretion. And that's the case of People versus Divine Fredericks. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.